Good morning, viewers. Welcome to Konosima Shorthand Classes. Get ready. 5 seconds. Start. To the question that the accused, having not raised the objection immediately on the expiry of the period of 6 months, if entitled to raise the objection at a later stage, unless he shows that he has been prejudiced by the continuation of investigation beyond the period of 6 months in Jaishankar versus State, it is held the accused was not required to raise any such objection, as the obligation was upon the magistrate to stop further investigation. The illegality remained an illegality, and the delay or failure on the part of the accused to point out the same will not make it otherwise. The question whether the accused has been prejudiced or not is thus wholly irrelevant. 2. An illegality committed in the course of an investigation doesn't affect the competence and the jurisdiction of the court for trial, and where cognizance of the case has in fact been taken and the case has proceeded to termination, the invalidity of the preceding investigation does not vitiate the result unless miscarriage of justice has been caused thereby. However, if illegality is brought to the notice of the magistrate in the early stage of the proceedings, he has to order reinvestigation or further investigation as the case may be. Complaints to magistrates under section 200 of CRPC, section 200 to 203, or under chapter 15 of the code, which deals with the complaints to magistrates. In case, on the basis of the material available, even without examining the complainant or his witnesses present, or directing the complainant to examine his witnesses, magistrate feels that prima facie case is made out, he has sufficient jurisdiction to take cognizance, and as a visible manifestation of taking cognizance, process can be issued straight away, and in that event, procedure under sections 200 and 202 ceases to remain very material. Once the cognizance is taken and process is issued, it can be either in the form of issuing summons or warrants, as the case may be. When a complaint is filed before a magistrate, he should either take cognizance of it under section 200 and proceed under chapter 16, or send the complaint to the officer in charge of the police station to treat it as an FIR and to proceed under chapter 14. He should not make a by bid composite order both under section 156(3) and section 202. There cannot, in law, be proceedings before a magistrate on a complaint and independent action by way of directing the complainant to examine his witnesses. The magistrate feels positive he can take cognizance and he can issue a process straight away. That's all.